So Donald Trump suffered a major setback at the Supreme Court, and the immediate significance went beyond a single ruling. For supporters of institutional checks and balances, it was a reminder that the judiciary has continued to resist political pressure, even as the rhetoric surrounding judges has grown more aggressive. That resistance did not begin with one case, and it has not ended with one opinion. One of the clearest examples came from the Federal District Court in Washington, where Judge James Boasberg ordered the administration to facilitate the return of Venezuelan migrants who had been sent to third countries after what he found were unlawful deportations. In February of 2026, he directed the government to pay for airfare and travel documents for any of the 137 migrants deported the previous March under the Alien Enemies Act. He described the violations as flagrant, and even the threat of contempt proceedings did not stop the administration from continuing to fight the order. That episode matters because it captures the broader pattern. The White House was not merely contesting a legal ruling on the merits, it was also escalating its public campaign against judges who ruled against it. In strategic terms, this was not only a courtroom dispute, it was an attempt to turn legal pressure into political leverage against an independent branch of government. Trump's public language toward judges followed a familiar script. After Boasberg pushed back, Trump used Truth Social to call him a radical left lunatic, a troublemaker, and an agitator, and he revived his recurring demand that judges who rule against him should be impeached. The words were theatrical, but the larger message was practical. Any judge who became an obstacle would be portrayed as illegitimate. The significance of that message increased when it was echoed institutionally. The Senate Judiciary Committee held a hearing examining impeachment as a possible response to what some lawmakers called rogue judges. Bloomberg then reported that senior Justice Department officials had asked federal prosecutors to identify examples of judicial activism that could support impeachment referrals to Congress. That is where the story stopped being a matter of overheated language alone. Once the executive branch begins searching the legal system for cases that can be repurposed into impeachment campaigns, the pressure on the judiciary becomes systemic. This is how institutional intimidation works in practice, not by formally abolishing courts, but by trying to raise the political cost of judicial independence. Even so, the courts continued to move. Boasberg was not isolated, and the response from the judiciary became increasingly explicit. Judges who normally speak through orders and opinions began speaking more directly about what they were seeing. At the American Bar Association conference in March of 2026, Ninth Circuit Judge Margaret McKeown drew a stark comparison. She likened calls to impeach judges for adverse rulings to tactics seen in authoritarian systems such as Turkey, Hungary, and Poland. Her question was simple and unsettling. Is this the United States? Chief Justice John Roberts also issued a rare public reminder. He stated that impeachment has never been the proper response to disagreement with a judicial decision. The point was narrow, but its meaning was broad. Courts can be appealed, criticized, and overruled through lawful process, but they cannot remain independent if adverse rulings are treated as impeachable offenses. That backdrop is essential to understanding the larger constitutional conflict surrounding Trump. While the administration was trying to pressure the courts in 2026, the legal record created in 2023 and 2024 had not disappeared. The most politically consequential findings against Trump were already in place, and they concern not immigration policy but the Constitution itself. The center of that conflict was Section 3 of the 14th Amendment, a clause written after the Civil War. Its logic is direct. Anyone who swore an oath to support the Constitution and then engaged in insurrection may be disqualified from holding federal office. For decades, it was treated as a historical relic. After January 6th, it became an active constitutional weapon again. What changed was not the text, but the willingness to use it. Legal scholars, election officials, and judges began revisiting a provision that had spent more than a century at the margins of public debate. Once revived, the amendment forced a question with enormous political weight. Did Trump's conduct surrounding January 6th amount to engagement in insurrection? The first major answer came from Colorado. On December 19, 2023, the Colorado Supreme Court ruled by a vote of 4-3 that Trump had engaged in insurrection. The court reviewed his speech, his public statements, and his failure to act while the Capitol was under assault, and it concluded that he was constitutionally disqualified from the ballot. Colorado was not alone. Maine Secretary of State Shenna Bellows conducted an independent review and reached the same basic conclusion. An Illinois judge did as well, meaning that in 3 separate jurisdictions, Trump was not simply criticized for his conduct, but formally found to have engaged in insurrection and removed from the ballot. That distinction matters. Political attacks can be dismissed as partisan. Judicial findings are different. They are written, reasoned, and entered into the public record after a formal examination of evidence. For a politician whose public identity rests on winning, dominance, and invulnerability, that was more than a legal inconvenience. It was a direct challenge to the foundation of his political brand. In 3 places, and the Constitution itself was being used to say that he was not fit to return to office, Trump's response was immediate and predictable. He went to the Supreme Court. The case moved with exceptional speed because the practical stakes were immense. Ballots had to be finalized, elections were approaching, and a patchwork of state-level rulings could have produced national chaos. On March 4th, 2024, the Supreme Court issued its decision. The vote was unanimous, 9-0. Trump and his allies celebrated it as a sweeping victory. But the actual ruling was much narrower than the public celebration suggested. The court did not declare that Trump was innocent of insurrection. It did not say that January 6th was not an insurrection. It did not overturn the factual findings from Colorado, Maine, or Illinois. Instead, it ruled on a procedural and structural question. States could not enforce Section 3 of the 14th Amendment against federal candidates on their own. In the court's view, that authority belonged to Congress. That distinction is the hinge on which the entire story turns. Trump got back on the ballot, but he did not receive substantive exoneration. The Supreme Court fixed the immediate election mechanics without wiping away the underlying constitutional allegations. This is why the ruling functioned as both a shield and a warning. It protected Trump in the short term from state-level exclusion, but it also relocated the conflict to a more dangerous arena. The court did not defuse the issue. It transferred the leverage. The lower courts and state officials that had reviewed the evidence left behind a record that remained intact. Their findings still stood in the public domain. Trump's speech urging supporters to fight, his pressure campaign against Vice President Mike Pence, and his inaction during the attack on the Capitol all remain part of the factual baseline those courts had established. The Supreme Court chose not to disturb those conclusions on the merits. That is why the political celebration had a note of irony built into it. Trump proclaimed total victory, yet the decision left untouched the most damaging part of the record. In legal terms, he won access to the ballot. In historical and constitutional terms, the label attached by multiple tribunals did not disappear. Labels imposed by courts do not function like campaign slogans. They can be challenged, appealed, and reinterpreted, but they do not vanish because a politician rejects them publicly. Once a state Supreme Court, a Secretary of State acting under legal authority, and a state judge independently conclude that the same conduct amounted to insurrection, the finding becomes more than rhetoric. It becomes a durable feature of the political landscape. The durability creates second-order consequences. Future litigants, prosecutors, and judges can cite those rulings as persuasive authority. They are not the same as a criminal conviction, but they are not nothing. They establish a documented constitutional narrative that can be invoked in later disputes over January 6th and its aftermath. This is the part of the story that carries real strategic weight. A politician can outmaneuver one case, delay another, and use procedure to buy time. It is much harder to erase a pattern of formal findings entered by multiple courts. That's all point in the same direction. For Trump, that is not merely embarrassing, it is dangerous because of where the Supreme Court placed the next decision point. By saying that enforcement against a federal candidate belongs to Congress, the court transformed a legal dispute into a political vulnerability. The argument advanced by Trump's critics is straightforward. If Congress is the body with enforcement authority under Section 3, then a future Congress hostile to Trump could try to act on the existing record. Under that interpretation, the threat did not end with the Supreme Court ruling. It simply changed hands. That is why the calendar became so important. The midterm elections of 2026 were no longer just another contest for House and Senate seats. They became a referendum on whether the institutional shield around Trump would remain in place or whether the constitutional question would return with force. If Democrats were to regain control of the House or both chambers, the theory goes, they could attempt to use the existing judicial findings as the foundation for congressional enforcement. They would not need to begin from zero because the evidentiary architecture had already been assembled in Colorado, Maine, and Illinois. Those rulings were not political talking points. They were pre-built legal ammunition. This is where the story acquires the cold logic of infrastructure and choke points. Trump spent years treating courts as obstacles to be routed around or intimidated. The Supreme Court ruling appeared to open a bridge back onto the ballot, but that bridge led directly into Congress, the branch whose control he now had to preserve. The very decision he celebrated created a new dependency. In business terms, this is what happens when a company survives one immediate supply shock only to discover that its entire distribution network now runs through a single bottleneck. The product still moves, but the vulnerability has become concentrated. For Trump, that bottleneck was no longer a state court in Colorado. It was a future Congress he might not control. That helps explain the intensity of his political engagement in down-ballot races. It was not simply party loyalty or routine campaigning seen through this constitutional lens. Every House district and every Senate race became part of a defensive perimeter around his own eligibility. The irony is sharp. Trump often presents himself as a figure too strong to be constrained by institutions, yet his survival in this framework depends on one of the oldest and most conventional realities in American politics, holding a legislative majority. The man who marketed himself as untouchable found himself dependent on committee chairs, swing districts, and midterm turnout. This is also why the judiciary's posture matters so much. The courts were not trying to resolve every political question in one stroke. They were doing something narrower and, in the long run, more consequential, establishing facts, preserving process, and refusing to yield to intimidation. In constitutional systems, that often matters more than dramatic language. Judges do not control elections, and they do not command political loyalty. What they do control is the legal record. So if they insist on building that record carefully and publicly, they can deny powerful actors the ability to rewrite reality after the fact. That is what happened here. Trump's public message was that he had been fully vindicated. The actual judicial record said something more complicated and more damaging. He had won a procedural reprieve, but the underlying findings of insurrection remained. The Colorado Supreme Court's extensive opinion did not disappear because the Supreme Court reached a different institutional conclusion about who may enforce Section 3. Maine's determination did not disappear. The Illinois ruling did not disappear. The constitutional stain remained, even if the immediate electoral consequence was postponed. This is why talk of a complete Trump victory in the Section 3 litigation misses the central point. A complete victory would have required substantive clearing of his conduct. It would have required a judicial statement that the evidence did not support the insurrection finding, or that January 6th could not legally qualify in that way. He did not receive that. Instead, he received what might be called a technical escape hatch. The court protected him from a state-by-state disqualification regime while preserving the possibility of federal enforcement later. That may have been institutionally prudent from the court's perspective, but for Trump it created a lingering problem rather than a settled one. In political terms, lingering problems are often worse than decisive defeats. A decisive defeat can be attacked, appealed, and rallied against. A lingering problem hangs overhead, shaping strategy every day because it can be activated by events beyond one's control. The unresolved threat becomes part of the operating environment. That is the context in which Trump's attacks on judges should be read. They are not only expressions of anger, they are signals of strategic anxiety. A politician who feels fully exonerated does not need to wage a broad campaign against the legitimacy of the judiciary. The pattern also reveals something larger about how institutional power works in the United States. Courts can be slow, Congress can be partisan, and public attention can be fragmented. But constitutional structures still create forms of delayed accountability. Sometimes the decisive consequence is not immediate punishment. Sometimes it is the preservation of a record that can later be used when the political alignment changes. Section 3 of the 14th Amendment is a perfect example of that delayed force, written more than a century and a half ago to keep former oath breakers from resuming power. It suddenly re-entered modern politics not as a historical curiosity, but as a live instrument. Trump was not threatened by it because the text changed. He was threatened because institutions were willing to read the text as written. This is the source of the deepest irony in the story. Trump survived an immediate attempt to remove him from state ballots, only to discover that the Supreme Court's reasoning redirected the constitutional threat to the national legislature. The legal firebreak held in one place, but the embers were carried into another. From that point forward, every discussion of congressional control carried a hidden constitutional dimension. A House majority was not just about tax policy, investigations, or appropriations. Under this interpretation, it was also about whether Section 3 remained dormant or moved from theory to enforcement. That does not mean disqualification would be automatic, simple, or politically costless. Congress is not a courtroom, and constitutional questions become more volatile when they enter openly partisan space. But the point is not certainty, the point is vulnerability. So the Supreme Court ruling did not eliminate it. Seen this way, the judiciary's resistance to intimidation becomes part of the same larger narrative. Judges like Boasberg, McKeon, and Roberts were defending more than their own institutional standing. They were preserving the idea that official findings once made through lawful process cannot simply be shouted out of existence. That principle is not glamorous, but it is foundational. Democracies do not survive only because elections occur. They survive because some institutions insist that facts established under law remain facts even when they are politically inconvenient. Trump's confrontation with the courts has therefore never been only about personality or even only about presidential power. It is about whether constitutional limits can still generate meaningful consequences for a political figure who commands mass loyalty and attacks the legitimacy of institutions that constrain him. The answer so far has been complicated but real. The judiciary did not remove him permanently from politics. It did something subtler. It placed findings on the record, rejected attempts at intimidation, and preserved a constitutional pathway that others might. That is why the story remains unfinished. Trump returned to the White House, but return is not the same as resolution. The courts have already done enough to ensure that his legal and constitutional exposure did not end with the election cycle. He still faces the burden of a public record in which multiple adjudicators concluded that he engaged in insurrection on January 6th. He still faces a judiciary that, despite pressure, has shown signs of holding its ground. And he still faces the possibility that a future Congress could treat the Supreme Court's procedural ruling not as closure, but as permission. In the end, the central lesson is less dramatic than the headlines and more consequential than the daily outrage. Trump's apparent victories in court have often been narrower than they looked. While the institutional costs to him have often been deeper than his public posture admits, he can survive a ballot challenge, attack a judge, and celebrate a procedural ruling, yet still emerge more dependent, more exposed, and more vulnerable than before. That is what makes this a constitutional story rather than a personality story. The issue is not only whether Trump can dominate a news cycle, it is whether the architecture of American government can still absorb pressure from a president who treats law as an obstacle and judges as enemies whenever they refuse to comply. So far, the answer has come in the language of orders, opinions, and quiet institutional warnings, a district judge ordering deported migrants returned, an appellate judge comparing anti-judicial rhetoric to authoritarian practice, a Chief Justice reminding the country that impeachment is not a remedy for disagreement, a unanimous Supreme Court ruling that gave Trump access to the ballot while leaving the core factual stain untouched. Those pieces fit together into a single picture. Trump may have escaped the most immediate consequences of the 14th Amendment challenge, but he did not escape the challenge itself. The Constitution did not close its file on him. It merely shifted the arena from the states to Congress and left the record standing. That is the unresolved reality beneath the public spectacle. The courts have not declared him untouchable. They have, in crucial ways, done the opposite. They have documented the danger, preserved the evidence, and refused to surrender their role as a firewall. Whether that firewall holds under sustained political pressure remains an open question. Whether Congress ever acts on the record the courts have created remains an open question as well. But the central fact is already established. Trump's legal exposure did not end when he got back on the ballot. It entered a new phase, and the institutions he has spent years attacking are still the institutions most capable of defining what comes next.